Sarah and I are delighted to be with you today. Really wish you could be in person, but this is the way that we do things right now. And I'll just introduce myself for a moment here and mute my phone, sorry. So I'm the chair of the Trust and Estates Practice Group at Buckingham, and our offices are in Canton, Akron, and Cleveland. And Sarah is the newest member of our group, and you can see that I've been practicing for a long time, and Sarah has been with us for about 2 years now. To her credit, she's just taken the Florida bar exam, so we're presenting you with two ends of the knowledge spectrum here. I bring maybe a little bit of wisdom and experience to the subject, and Sarah brings energy and vitality and youth. So we're covering all ends of the spectrum today. And wanted to tell you what our format is. We are going to try to walk you up what we call the estate planning pyramid. And it's a way that I developed several years ago to try to make a complex subject more simple. And the way that we will make it simple is by cutting it into pieces and parts and kind of describing what at the bottom of the pyramid is, are some very basic but extremely important documents. And then we will be going up the pyramid and answering a lot of questions about trust. I was delighted that Julie had some questions already submitted, and they fit so well into the topic that we're presenting today. I think it'll bring some vitality and life and spontaneity into the program. We will talk about the proper titling of assets, which is so critically important to avoid probate. And then at the top of the pyramid, if we have time, we would love to talk with you a little bit about, the wonders of charitable planning and how that can be an incredibly rewarding and important component in your estate plan. So I introduced Sarah a little bit, and she's going to lead us off. But I did want to say that we often start these presentations with, what is our goal? What are we trying to accomplish? And I think it's very simple. Our mission today and our charge is to do one of two things. The first is, if you already have existing estate planning documents, we'd like you to consider revisiting them. That's a really important part of having a quality estate plan, and that is to review and revise as the need may come up in the future. And the other thing that we'd like to do is, if you don't have estate planning documents, we'd like to convince you how important that is, and then provide kind of a schematic for you to do that without fear. A lot of people are, I don't want to say they're afraid of the process, but they just don't know where to start. And our purpose today, by using this pyramid, is to tell you where to start, to get you engaged in the process, and then ultimately to try to get you to do the right thing for yourself and your family and your beneficiaries and your kids and maybe your charities. Because there's no question that you are much better off doing proactive estate planning and not falling into the safety nets that the law provides in the event that you don't have these documents. So what I said so far is that this is the first time I've ever done one of these presentations. I know nothing about the subject, and that Sarah is going to be in charge of everything. That's what I've said so far. Just kidding, just kidding. But I am now going to say that having given you kind of the preliminaries of what it is that we hope to accomplish today to motivate you to do estate planning or to review the estate planning documents that you have, I'm turning it over to Sarah.
Hello, everyone. As Ron said, my name is Sarah Blank, and I'm an associate here at Buckingham, Doolittle Burroughs in our Trust and Estates Practice Group. I am actually a Florida native, and I've been in Ohio for about 5 years now. I just recently moved to North Canton, so I'm right around the corner from you all. So as Ron talked about, we're going to start with the pyramid. So I'm going to start at the bottom of the pyramid and talk about these 3 critical documents that pretty much everybody should have. So we have the financial power of attorney. You have your healthcare documents, which include both your healthcare power of attorney and living will, if you decide to execute one. And then, of course, your last will and testament. So starting with your financial power of attorney, one of the most important aspects of this document is to prevent a probate court guardianship. this is a document that allows whoever you name as your agent to act in your capacity for multiple financial matters on your behalf. And what the problem with guardianship is that it's something that the court has to oversee. So by having this financial power of attorney, you're able to keep your private matters private and help plan for the unexpected. So this document can either be current or it can be springing. So we recommend it always be current. So kind of the difference between the two, I'll start by explaining what a springing power of attorney is. So a springing power of attorney is one that only comes into play if you were to become incapacitated and were unable to act on your own behalf for those financial matters. But where that becomes a problem, and the reason that we recommend that you have a current financial power of attorney, is because the whole point is to keep your matters private. And if somebody has to declare you to become incompetent, then that could lead to litigation, that could lead to other unexpected problems. So by having this current power of attorney that somebody's able to act on your behalf immediately, it kind of helps you plan for the unexpected and avoid entering in any probate court guardianship problems that may arise in the future, because you have this form already intact. And what we execute is called a durable general power of attorney. So this is going to be for all matters. So that's a general power of attorney versus a limited power of attorney, is if that's more so in the case if you were out of town and you need somebody to help sign documents because you're selling your house and you only need it for that limited portion. We can always execute those for you, but those are kind of just on a need by need basis. Whereas the basic document everybody should have is a durable general power of attorney to help with those unexpected matters that may arise. And just recently, well, I guess not that recently, but in 2012, Ohio enacted some new laws that were meant to prevent elder abuse. So what these laws really do is that they provide that whoever you name as your agent that's able to act on your behalf for these matters is unable to act unless the specific hot powers, or what they are called, are listed in the document. Because if you just refer to somebody as your attorney in fact or my agent, and then they bring that document to a financial institution, they need to know what powers really that person can act on your behalf for. So it was really, these laws were important, and they work in order to prevent anybody from being taken advantage of, because this document is so powerful and people can act on your behalf for lots of things, and they want to make sure that people are using it appropriately. And then
let me just describe what those hot powers are. Sometimes we talk about them being like game changers. They're like the ability of your agent under a power of attorney to change a beneficiary on a life insurance policy, on an IRA, on an annuity. That's you could have a situation where that one asset constitutes 90% of your overall net worth. And if that agent is going to have that kind of authority, that broad authority, the law says you really need to spell that out. As a matter of fact, in Florida, where both Sarah and I are licensed, you even have to initial that specific power. Others are like to be able to make gifts on your behalf, which can be extremely important in an estate planning context. But that's something which is such a powerful authority. It's called a hot power. So if your documents are older than 2012, doesn't mean that they're invalid. It's just that you might get a little bit of a pushback from a bank or a brokerage house who's looking at an older document and it doesn't have these hot powers included in it. So that's an important aspect of your power of attorney. And before I give the floor back to Sarah, I just wanted to talk about, guardianship in probate court and how cumbersome and expensive and time consuming it can be. And every one of the documents that we're going to talk about today has the purpose of kind of taking you out of that default system, that safety net. And it's the notion that if you do these things proactively, you're going to be a lot better off, and your family is going to be a lot better off than if you fall unintentionally into situations like a guardianship. But, despite the fact that you have a power of attorney, there could be a situation where a guardianship is imposed against you, but with the power of attorney, it can only happen in two circumstances. You are either so neglectful of yourself that the court has to take care of you or appoint somebody to take care of you, or you are such a threat to others that the court has to get involved to protect the public. So these powers of attorney, by the way, because people are living longer, become critically important in order to maintain flexibility, in order to be able to do things that need to be done in the future that you can't even anticipate today. And in the absence of a financial power of attorney, if you have a significant disability or incapacity, you're going to be thrust into this probate court guardianship, and that flexibility for changing your estate plan is going to be eliminated. So Sarah, that's all I got to say about the power of attorney.
Yep, no, jump in whenever you need to. That's why we have Ron here. I am definitely the expert. But so with that, so we'll draft these powers of attorney under Ohio law. However, they are accepted everywhere else. And in order to comply with all the other states' laws, even though Ohio only requires them to be notarized, well, signed and notarized, we also provide witness document or witness lines as well. So that way, you know, for example, in Florida, they do require to have it notarized and witnessed. So there's no question as to whether you can use your Ohio power of attorney in another state. So that's kind of the overview of your financial aspects of things. So your durable general power of attorney. And now moving forward to your healthcare documents. So these documents are created by the state of Ohio, and they include your healthcare power of attorney and your living will. So your healthcare power of attorney is where you appoint an agent to make your healthcare decisions on your behalf, if you are unable to make those decisions for yourself. So compared to what we were just talking about with the durable general power of attorney and having the option of it being a springing document or it being in effect immediately, these healthcare powers of attorney will only come into play. They're only springing documents, and they will only come into play if you become incapacitated. So what does that necessarily mean? How we define it is if you are in a permanently unconscious state, and then you need two physicians to declare you in that permanently unconscious state. And then at that point is when they will turn to whoever you have appointed in this document as your agent to make whatever healthcare decisions need to be made on your behalf. And then also they use the term if you're in a terminally ill condition. However, with that, you could be in a terminally ill condition and they could declare you so, but if you're still competent enough to make the decisions on your own behalf, your agent doesn't have the authority at that point. So, you know, for example, if you are in something like kidney failure but you are still, you know, awake and competent and able to make your own decisions, you can deny or accept whatever treatment you deem appropriate for yourself at that point. Your agent can't overrule your own thoughts and your own decisions. So then in this document, you are instructing your agent as to your decisions and appointing your agent. So the difference between your healthcare power of attorney and then your living will is that in your living will, if you decide to execute one, you are specifically instructing your physician as to your end of life decisions. So where it becomes important is if you are in this permanently unconscious state and your healthcare agent, whoever you have appointed, is there to, they're in that position that they have to determine whether you would want to be kept alive by artificial means or not. Here, you are instructing your physician that you do not want any artificially or technologically life-sustaining measures or any hydration or nutrition, and they would only be providing you comfort care. So by executing this living will, you're instructing your physician as to that opinion of yours, rather than making your healthcare power of attorney make the decision for you. So that is kind of the overview of those two documents. And then also in the living will, it does provide you the option for a donor registry. So a lot of people will take care of that at the BMV, and they'll put it on their license. However, what they have is they call it an anatomical gifts section, and you can decide whether you want only certain organs to be donated, or if you only want certain organs to be donated for a particular purpose. So it's, a lot of people will just check all or leave it blank. It's completely optional again to fill out, but it is something else that gives you an option for you to make decisions as to your own end of life care while you're living.
So I want to just chime in on a couple of things and maybe focus on some aspects that Sarah just discussed, but bear with me. So these forms are generally the prescribed forms that are available from many resources. And I think Julie just mentioned that these are available from Altman perhaps, and I did see something with reference to Western Reserve Area Agency on Aging, and that's true. So 2 points about that. When you look at those documents, initially they look very, very much alike. They have the same definitions. You look at the bottom of the form and it's the same wonderful healthcare agencies that work together to promulgate these documents. And people say, so like, do I need both of these, or how is one different than the other? And the simplest way that I can describe the fundamental difference is that when you sign a living will declaration, that is you speaking affirmatively and directly to your healthcare provider. And as Sarah indicated, if it happens that you are in one of two defined states, either permanently unconscious, and the second one is in a terminal condition and unable to make your own healthcare decisions, then the provisions of the living will tell your doctor, your healthcare provider, that you do not want to be sustained artificially. So that's fundamentally different than what a healthcare power of attorney does, which springs into existence at the moment that a healthcare provider determines that you cannot give informed consent, that you are not knowledgeably able to participate in your healthcare. So a healthcare power of attorney can be in place for a short period of time, and it can be about relatively mundane issues. You're just, under anesthesia, you're temporarily unable to provide for yourself. So that document can come and go. It can be used multiple times over one's lifetime, and sometimes for very, very simple things. So the living will, however, is going to have that triggering event, those necessary triggering events of permanently unconscious or terminal condition and unable to make your own healthcare decisions. So they're both very important documents, but they have very different purposes, although they look alike on their face. One last point, and then I'll get off my soapbox, but because these are uniform documents, people think that they can't change them, or there are no choices, or that they can't be embellished. And in the document right there are provisos that say, here's a space where you can add additional instructions or limitations. So although it's a form document, please don't feel that they can't be personalized. They should reflect your wishes, your thoughts, and in a lot of cases, religious beliefs. So we spend an awful lot of time with our clients on these documents because they take on such added importance in the world of healthcare. Okay, Sarah.
All right, so I think we beat that one to death. So we're good with the health. And then now moving on to the last part of the bottom of our pyramid, what you most likely thought the whole presentation was going to be on is your last will and testament. So of course we would advise everybody to have this last will and testament. And later on we'll talk about trusts, and I know a lot of people will have questions on that. But this is going to be one of those baseline documents that everybody needs to have. In some cases, it'll just be a safety net. And that's probably what we try to plan for mostly, whether you have a trust or not, because as we'll get to, there's the titling of your assets that'll still allow you to avoid probate, even though you don't have a trust. So what is a probate asset? So a probate asset is something that is in your name individually and does not have any beneficiary designation to it. So for example, your checking account, if that is just in your name individually and it's not joint and survivor with your spouse or a child, upon your death, that'll become a probate asset because there's no instructions as to where to leave it other than what's in your will or what's in the intestacy laws of Ohio if you don't have a will. So also for real property, if the property is in your name individually, it's the same setup. If you're not joint owners with somebody with rights of survivorship, then upon your death, it will pass through the probate process. So it's not always the worst thing in the world to go through probate, but if you're able to avoid it, it's definitely makes it much simpler for your family after you're gone. So there's ways of doing that that we will get to when we talk more about titling. However, so what we usually like to call the will is a cleanup hitter. And for that reason, it's if you don't have all of your assets titled to where they have a beneficiary or a joint owner on them, this is where the will is gonna catch all of those assets and make sure that they're going exactly to whom you would like them to go to upon your death. Another very important aspect of the will is if you have minor children, this is the document in which you would appoint a guardian to act, or a guardian for your children if both parents are not around or able to act for their child. You would also be appointing an executor, and that is the person that will work with the court and make sure that all of your assets pass accordingly to what's stated in your last will and testament. So there really two, of course, your will can be customized however you want it, and you can make it state whatever you need to say. And this is something that we would work with you on, or whoever your estate planning attorney is would work with you on. But there's really what we call an I love you will, which is where if you have a spouse, you leave everything to your spouse, or otherwise you leave everything to your kids, just kind of the general setup of what most people would want. Or we have what's called a pour over will. And this is where if all the assets aren't titled in the name joint with somebody else, joint and survivor, or that don't have a beneficiary designation on them, it would catch all of those assets and then pour them over into a trust. And that would be your revocable living trust, which Ron is going to get to a little bit later today. So those are the two big bucket types of last will and testaments. So there's also the option if you have, and I know one of the questions today was regarding disinheriting somebody. So you can provide in your will what's called a will contest clause that says if so-and-so decides to challenge this will, then whatever would be left to them, or they will not receive whatever is left to them in this will, or would otherwise if the will was invalidated. So it's just kind of, some states don't allow it. For example, Florida doesn't allow it, but Ohio allows you to insert that clause so that you have some peace of mind, so that if somebody were to challenge your will because they didn't feel that they got what they deserved from your estate, they can still be disinherited just on the basis of them challenging it.
Just a final word on the will before we move on to probate avoidance devices. Question flashed across the screen about, can you have more than one executor? The answer is yes, and sometimes that creates more problems than it's worth, because if you can't build a consensus between those co-executors and a decision has to be made, nothing will happen. The same question could legitimately be asked about the power of attorney. Can I designate two people to be my agent to act in my power of attorney? And the answer is yes, but you do run the risk that you could have a deadlock. So then what do? Do you bring in a third person? So when you visit with your estate planning professionals, they're going to lay out for you the pros and cons of all these approaches. And an important point is that just because your neighbor has it set up a certain way doesn't mean that it's appropriate for you. And that's where the personal touch in estate planning comes in. And that's why having a relationship with, an estate planning team, your attorney, your financial advisor, your insurance agent, your accountant, all of these people know the nuances of your family and will work together to get you the best result. So there's absolutely no rights or wrongs universally. It's just what's right for you in your particular situation. Okay. Sarah?
So as we talked about what probate property was, we use different methods and avenues in order to try to avoid going to probate or going to the probate court and using that last will and testament. So for example, one is joint and survivorship. So that would be, for example, real property. A lot of times you'll be joint and survivor with your spouse or whoever's on there. And on the deed, it'll say with a right of survivorship. And at that point, what that means is that when one of the owners passes away, the other owner automatically is the 100% owner of that property. So there's no need for probate at that point. You take the death certificate and you have an affidavit filled out, and then you go to the recorder, or you go to the county recorder where the property is, and then they transfer the property all to the surviving individual. And then Ohio also allows what's called a transfer on death designation affidavit. So using the same real property, if you are the sole owner of your house or your home, and you want to designate a certain individual to acquire that property upon your death, you can fill out this affidavit, which automatically transfers to that individual you named the real property without having to go to the probate court or designate that they should receive that property in your will. So it's just another form of probate avoidance. And we can also do that, or Ohio allows you to do that with your motor vehicles. You can do that with other certain assets that have titles to them. And then the last one really is either payable on death or beneficiary designations. So payable on death really refers more to like bank accounts or, liquid assets rather than real property and motor vehicles that we were just talking about. So a lot of different types of, money market accounts or investment accounts, they'll allow you to have a payable on death beneficiary. Same thing with your retirement accounts, which we will get to hopefully at the end if we do have some time. So all of those are important to either know that you have them titled with a right, with the joint and survivorship right with somebody, because that's a probate avoidance tool, or you can make sure that you have a beneficiary designated with that account or that specific asset of yours.
I could just go to my cautionary tale there, joint and survivorship, extreme caution, I'm sorry, I should say extreme caution. I apologize. Extreme causation required. My bad. But so what did I mean by extreme caution required? People are under this misconception. Let's say it's a surviving spouse and they have 3 children, and they come to me and they say, well, I want to put my daughter, Bernice on this title because when I pass away, I want to make sure that it avoids probate. And if I leave it to Bernice, I know that she's going to do the right thing and she will divide it up with her 2 brothers as well, because that's my intention. I want it to be a third, a third, and a third. So she goes to her grave believing that Bernice is going to do the right thing and split the asset 3-way. The law in Ohio and all of the estates is that, how you title that asset is going to control over what you say orally, over what your will says, over what your trust says, because you titled that specific asset in a specific way. So Bernice, mom dies, Bernice inherits the property, and her siblings say, where's my 1/3? Bernice sometimes says, okay, I'm going to do the right thing and I'm going to give you 1/3 of the proceeds of the house. But Bernice is under no obligation to do that. So that creates a very untenable situation. The other area in which this caution is required is that you will put a child on a piece of real property. That person becomes a current owner of that property. They go through a divorce. They are involved in an automobile accident. They cause injury to a 3rd person. That house is at risk. You're not able to later say, wait a second, that house was mine. It should not be subject to loss in this other lawsuit. The daughter has become an owner of that property. And so it can have, tremendously unintended consequences. And that's why in Ohio, the beauty of transfer on death and payable on death becomes so evident, because transfer on death or payable on death is completely revocable at any time up until you die. And the person that you named as the transfer on death beneficiary has no ownership interest in that property whatsoever unless and until you die. So very, very important considerations in choosing how your assets are titled. Okay. And I see that Sarah has put up the slide that, kind of drives home these points. How you title these assets will take precedence over your will or your trust. It's so easy to do, and that's where the risk is. A lot of people will make these determinations on their own without, professional advice. They're well-intentioned, but they don't understand the full ramifications of how the titling will work. And you need, extremely important, to review this stuff after somebody passes away or after you go through a divorce. I can't tell you how many situations we have where people will go through a divorce and then not immediately redo their estate plan. So the question arises, well, they left the spouse on as the beneficiary of a life insurance policy or a retirement plan. That must be what they wanted. Who knows? And so if you go through a life-changing event like, losing a spouse or losing a child, that's a big trigger event to review your estate planning at that point in time. And then the last bullet point on this slide is there are special issues with ERISA plans. Frequently we'll have people in second marriage situations saying, look, I've got this large IRA, I've got this large qualified plan, and I would really like that to go to my children. I don't intend that to go to my recently married spouse. Well, guess what? If it's a pension plan, in the absence of a prenuptial agreement, you don't have the ability to switch the beneficiary away from your brand new spouse. So that requires super extra special planning to avoid that result. So titling of assets, it's just so critically important and not something that people should just cavalierly say, I can make these decisions on my own. You need the intervention of your accountant or your attorney to make sure that you're doing the right thing, especially in blended family situations, critically important. So, sorry, Sarah, I think I talked through your slide there. Huh?
No problem. Now you get to talk some more because we're moving on from last will and testaments to whether it's necessary to have a trust or not.
Okay, so, like in all of everything, all of estate planning particularly, I mentioned there are no absolutes. So there's no particular level of wealth. There's no particular family circumstance. There's no particular age at which we have to say, oh yes, you need a trust. But there are kind of hallmarks out there. And so one answer is, do I need a trust? And the answer is, if your estate is big enough to have federal or state estate tax consequences, you really should consider the benefits of a trust. So let me stop there for a moment, because part of the topic today was estate planning in 2021. So what's new in 2021? Well, you are probably aware that we have never lived in a time when the federal estate tax exemption is as high as it is now. I'll give you the number and then I'll tell you what it means. Every US citizen can pass $11.8 million worth of assets to anybody that they want without fear of federal estate tax consequence. When I first started practicing, you know what that number was? $600,000, and now we're at $11.8 million. So if you are at a level of $11.8 million, or you and your spouse are at $23 million, you really need to consider the benefits of a trust to help mitigate those taxes. But here's what's going on, and this is the 2021 aspect of the presentation, or at least one of them. There is significant talk in Washington that that very favorable $11.8 million exemption is going to be reduced to something like $3 million. And this could be done with a, the Democratic Congress that we have, the Democratic president that we have. They would have the ability to roll back some of these limits that were expressed under previous administrations. So what's happening in 2021 is that parents and widows and widowers and even single individuals are considering whether they need to make a large gift during their lifetime to their children in order to use this huge exemption as it exists now, rather than letting it go to waste. And that's a whole nother topic, but just be aware of the fact that that kind of tax legislation is probably going to be on the horizon, okay? But even in the smallest of estates, if you have beneficiaries, these are the people that you care about, these are the people that you love, that have a disability, an addiction, are in a terrible marriage, have debt collectors chasing them, are in trouble with the Internal Revenue Service, or they have mental health issues, you probably need a trust in order to protect them. And this is a good time for me to talk about one of the questions that we received. And in general, it said something like, well, I think I can be more than general. I think I can read it because it's completely anonymous. And it says, we have 2 adopted daughters whose adult lives have included drug and alcohol abuse and jail time. In our current will, we stated that we are choosing not to leave anything to them. Could that lead to the will being contested? We have 2 other children. So the answer to that question is that if you wanted to provide at all for the 2 children with the drug addiction, that means using a trust. But to answer the other question is that when we do things, when you utilize a professional, people can be upset about your will. People can say it's unfair, I should have participated. But if you do it right, people don't have an automatic right to inherit just because they're children. Children inherit as a matter of good graces and because you want them to inherit. So with a well-drafted, well-orchestrated will or trust, with all of the proper execution formalities, you don't have to leave property to people that you don't want to leave property to. So we will get the property to the folks you want and keep it away from the folks that you don't want to inherit. Okay. So one other question in the trust vein. I put my assets into a revocable trust. Can a nursing home force me to revoke the trust so that they can access my assets? And the answer to that question, unfortunately, is yes. They can make you spend down that revocable trust. And Sarah and I do not do Medicaid planning, but I can just tell you as a matter of common sense and common experience, because a revocable living trust is amendable and changeable by you at any time for any reasons, it doesn't create current asset protection. You need to do an irrevocable trust, and the assets have to sit in that trust for 5 years before you would file a Medicaid application. So that's 2 of the 4 questions. I'm going to get back to the slides at this point. Do you need a trust? If this is a second marriage, a blended family, you probably do. And here's the reason why. Remember that I love you will that Sarah mentioned? So a blended family could have an I love you will that says, I leave my property to my spouse, Frank. And if Frank predeceases me, then I leave all of our property to each of our 7 children, 3 on my side and 4 on his side. So the spouse dies, Frank survives, Frank inherits everything, and he changes the will, and he leaves everything to his new spouse. And it could be a second spouse, it could be his third spouse. So you need more protection than the will to prevent against that result. And the mechanism to do that is a trust in which you say, I grant my spouse the ability to utilize these assets for his health, education, maintenance, support. But to the extent that there are assets left in this trust after he passes away, it's going to all 7 of these children in equal shares. So that's a situation where a will is insufficient and a trust is tailor-made to handle that kind of a circumstance. Okay. If your estate is very small or somewhat small and you don't have any of these concerns, and let me give you the ultimate situation. You have 1 bank account with $500,000 in it, or 2 bank accounts with $250,000 in it, and you designate your sole child as the beneficiary, and that child has nothing going on, not threatened with a divorce or any of those bad habits that we previously discussed, you probably don't need a trust at all. You can just designate that person as the beneficiary and have a great quality power of attorney, and that's probably all that you need. Okay. Yeah, so Sarah put up my famous last words, which is, okay, I promise to divide it equally between all of the kids, right? And this happens in like even IRAs. This is the one where we see it all the time. People have large IRAs. It's a second marriage. Their primary beneficiary is their spouse. So their spouse inherits the IRA. And even though that spouse promised to divvy up everything amongst all 7 children, the spouse over a period of time becomes disenchanted with the stepchildren, or they become elderly and one of the kids works them real hard and they change the beneficiary designation to be their own children to the exclusion of the stepchildren. So this is a situation, again, that requires careful planning and a trust, and a simple beneficiary designation to a second spouse may not get the result that you hope. Okay. And I think that's enough to say on that particular subject. So Sarah, were you going to talk about these trusts, or was I going to say a few words about these?
I think you can say a few words about it and then we can move on just a little bit because I know we're getting short on time. We want to leave some time for questions.
Okay. Let me see if there's something that just jumps out at me on that types of trust. I guess I would say this to you. When you're an estate planning attorney, it's like being a physician or a doctor in this respect. You have a patient or a client come in and you have this continuum of options. You can go from revocable trust to irrevocable trust. You can go through, just a simple will and just simple beneficiary designations to completely complicated and convoluted plans because that's what the situation requires. So what you're deciding with your estate planning professional in conjunction with your accountants and your financial planner is which of these prescriptions is right for your condition. Is a revocable trust good enough? Should this be a lifetime trust versus only a death time trust? Should the kids get the money outright, even in a trust when you die? Or do we need to encapsulate it in some kind of a trust for their benefit so that it's not spent improvidently? Do you want to make charitable gifts or only non-charitable gifts? There are income tax ramifications to each of these trusts that we do. One is called a grantor trust, where you continue to bear the income tax consequence on the income that's generated by the trust. A non-grantor trust means that the kids are going to pay their own tax liability. So the summary of that whole slide is that there's this continuum of choices, and the job of the estate planning professional, along with your other professionals, is to pick the one that's best for your family. And there's no perfection, by the way. There's no perfectly right or wrong answer. You just have to do the best that you can do under the particular circumstances and run with it. Okay. Sarah, this is your bailiwick. Sarah is our Secure Act guru at the firm. So just, this is not a 2021 change, right? But pretty darn new, Sarah.
Yeah, so the Secure Act was enacted at actually the beginning of, it was the end / became law at the beginning of 2020. And what Secure stands for is setting every community up for retirement enhancement. And I will not take credit for Ron's new acronym for it, but it is Secure Act as subverting every careful undertaking of retirement endeavors. Because really what Congress was doing by enacting the Secure Act was trying to find more ways to collect some tax dollars. So just looking at the big picture of everything, how does it really affect you? So one of the things the Secure Act did is it increased the required minimum distribution start date. So prior to the Secure Act, an individual was required to start taking their minimum distribution amounts at age 70 and a half. But Secure Act changed that to now 72 years old. So that sounds helpful. However, part of the reason that they did that was because they changed the inherited IRAs. So normally prior to the Secure Act, if you had, say, let's just use $1 million IRA, and you wanted to leave it to your 2 children. At that point, at your death, when they transfer the IRA to your 2 children, they would be able to stretch that amount over their life expectancy, which is all part of a chart that IRS puts out. So, you know, as for retirement assets, those go in as pre-tax dollars. So whoever inherits your account upon your death, whenever they take their required minimum distributions, they're going to be, that's taxed as their income. So the Secure Act actually did away with this, what we call stretch IRA, and instead replaced that with the 10-year rule, which means that whenever you leave your retirement account to an individual who is not an eligible designated beneficiary, which I'll get to, that individual will only have 10 years to completely deplete all of those assets. And at that point, if they don't have all of the assets out of the IRA within the 10th year, then they are going to be stuck with a huge income tax bill at the end. So that is going to take a lot of planning with their financial advisors to determine the best method of depleting the account within 10 years. However, when I refer to as eligible designated beneficiaries, those individuals will still benefit from this stretch IRA. So there's 5 different types of eligible designated beneficiaries. They include the surviving spouse, so you can still leave it to your spouse. They still have all the same rollover benefits that were there prior to the Secure Act, or they can stretch it out throughout their lifetime if they choose to do an inherited IRA. It also benefits your minor children until they reach the age of majority. So that doesn't include any grandchildren or other minors. It has to be your specific minor children. And the age of majority, because it is still a new law, we're waiting to hear what that is. It could be different in every state. So it could be anywhere from 18, 21, or 26. So that'll, as law comes out, we'll know more about that. So I talked about surviving spouse, your minor children.
Chronically ill.
What was that?
Chronically ill.
Yep, chronically ill individuals, disabled individuals, and those are both defined in the Internal Revenue Code, I believe, right, Ron?
Mm-hmm.
And then the last one, really it's your siblings, but that's just it's not necessarily your siblings, it's anybody that's within, or that's not more than 10 years younger than you. So that could be a non-married partner, or that could be your siblings, it could be any individual, but they can't be more than 10 years younger than you. All of those 5 categories of individuals will still benefit from this stretch IRA, but everybody else is going to have to deplete the entire inherited account within 10 years from the year following your date of death.
Mhm.
And then, so with all of that negative stuff, the one other good thing I guess they did is they eliminated the age restriction for making contributions. So prior to the Secure Act, you were not allowed to make any more contributions to your IRA starting at 70 and a half. The Secure Act has done away with that, and you can keep contributing for as long as you would like. And then I might turn this part over to you now, talking about the qualified charitable distributions.
So I chair my parish's finance council, and we are, of course, completely wanting to know the sources from which charitable contributions are coming in. And the emphasis has switched away from, kind of weekly tithing and really moved to what's called qualified charitable distributions. And the beauty of this is that you are able to use all or part of your required minimum distribution. Instead of you taking it into your income and then making a contribution to a church or to Altman or to whoever you want to make a contribution to, you can do it directly from your IRA to the charity. It is not taxed to you. It is not taxed to the institution, and it is seamless. And so people are setting up regular distributions from their IRA to their favorite charities and letting the government pick up a part of the cost of doing that. So if you are 70 and a half years of age, if you don't need your RMD to live on, your required minimum distribution, and you want to do something nice for a charity, you can set up one or a series of qualified charitable distributions, and it's a fabulous, simple, seamless technique. And I just can't recommend it more highly to the right kinds of individuals. It will just be terrific. Okay. You know, Sarah, I think that on this one, we have like 6 minutes left, and I can see we got some great questions. And so charitable gifting, but let me just say this to you. If you're inclined to do charitable gifting, there are a whole bevy of arrangements and possibilities. We mention this because this is the top of the pyramid. Once you've navigated through all of these other questions, and if you have the ability to leave a charitable gift, believe me, Sarah and I and your accountant and your personal estate planner have the mechanism to get great results in terms of charitable giving. And I think that's all that I'm going to say about that slide because of these great questions that came in from the audience. So do you mind, Julie, if I just go and answer one of these or more?
No, that would be great. Yeah, go ahead
Okay.
and answer those, and then we can even then unmute people to allow them to ask questions.
Okay. So we don't have a hard immediate cutoff, or can we go a few minutes later if we need to do that?
Yeah, no problem.
Okay. So first, great question. Can I make the house transfer on death, or is that to be written out in a will? So the answer is yes or no. And I'm not trying to be lawyer-like about that, but the answer really is it depends. Because you can definitely do a transfer on death affidavit or a piece of real estate, whether it's your house or a commercial building, and it would say, I own this property right now, and if I still own it at the time of my death, I want it to be transferred to this person, which is great. What's really not great is if you're going to transfer it to more than one person or several people, because at the instant of your death, this house is owned by all of them equally, and they're going to have to agree, is it going to be sold? Is one going to buy it out from the other? What's the purchase price? So in that case, it's one of the few situations where we may say to you, look, you're better off just disposing of it in your will, having one executor take charge, and everybody can get their, say, 1/3 share of it, but it will be so much easier than 3 people. And by the way, in Ohio, we still have dower rights. So it might not only be the 3 beneficiaries, it might be their spouses that have to agree on all aspects of the disposition of the house. So depending upon your circumstance, either one of those could work, okay? Next great question. Is it legal to just write out your wishes and have it notarized without going through an attorney? Well, there's certainly nothing in the law that says you have to use an attorney. You can be your own attorney, but this is one of those cautionary tales, okay? Lots of people can navigate through LegalZoom and do it that way. And in some cases that works just great. But if there's anything tricky, if there's anything you're unsure of, it's like, you know, why would you risk, you know, catastrophic results and create potential infighting in your family in order for a minimal savings on attorney's fees? So yes, you can do it. Just to be clear, a will doesn't have to be notarized. It just has to be witnessed, but witnessed properly. The one thing we see all the time is somebody does a will and they put 2 witness lines on it, and their 2 kids are the witnesses to their will. Those are disinterested and disqualified witnesses that would invalidate the will. So yes, you can do it on your own. You know, you can also fix your own brakes, and you can also do, you know, your own brain surgery, I suppose. The question is, why do you want to do that? Why do you want to take the risk? And then one more, okay, before I get out of the question section. And this was a good one that I wanted to save. How can I include my 8-year-old grandchild in my will? Do I need a trust to leave something to my grandson? And again, this is the, which arrow in our quiver will the estate planning professional choose to use? So you could definitely do a trust and say, I leave this property for the benefit of my 8-year-old grandson. You can't leave it to the grandson, but you could leave it to a trustee for the benefit of your grandson. And what I want to spend the money for is his education or his maintenance or his living costs. And you can do that in a trust. You can also do a shortcut, which is called the Ohio Transfer to Minors Act, which will let you designate a custodian, and the custodian gets to dole out the money to the beneficiary under the terms and conditions that the beneficiary, that the custodian deems appropriate, but not later than the 25th birthday of that child. Every dollar has got to be out of the account. So sometimes that's a great shortcut, and a lot depends upon the amount of money. Would I put $1 million into an Ohio Transfer to Minors account? No, I would do a written trust instrument, okay? But if it's a small sum of money, take the shortcut and do the Ohio Transfer to Minors Act. I think I said trust before, but Ohio Transfer to Minors Act. So those are all the questions that I am aware of, Julie, unless you see some others out there. And Sarah may have a concluding remark because it looks like she wants to say something.
Reading my mind. No, I do hope that we were helpful for everyone today. And I think we covered a lot in a short time, and just reiterating that everybody's estate plan is going to be different. So if you talk to whoever your estate planning advisor may be, just know that what we talked about today is just the tip of the iceberg, and there's lots more that could be discussed. And so hopefully we are able to help you with some basic ideas of it all.